Yes.
Okay, you have a seat, sir. Okay. All right. Mr. Espinoza? Espinoza? All right, sir. We are here today for a bond hearing in your case. All right. Counsel, you may proceed.
Good morning, Your Honor. I am Arnold Regas, and I am going to be brief. I guess in some regards, I am asking for a bond in this case to some extent for all of the wrong reasons. Normally at a bond hearing, I would talk about a person posing no significant risk of life, no significant risk of harm to their personal property, no significant risk to commit a felony, or no significant risk to harm any witnesses. But I won't be saying those things in this bond hearing because as we sit here, Mr. Espinoza is severely mentally challenged and is struggling from delusions, irresistible delusions that he has struggled with for the last few months and to some extent the last several years. He was released from a mental institution, in fact, just this past January. So I won't be saying the things I would typically say, but I will be asking for a bond almost because of those things. He does pose a significant risk to the community. He does pose a significant risk to commit a felony. He does pose a significant risk of flight. But the problem and the reason he poses those things is not because necessarily of his condition. It is because where he is being housed in the Fulton County Jail, they are incapable of medicating him and treating him properly so that he will no longer pose those risks. So the fact that he does pose a risk in many significant regards is a symptom. But unfortunately, the disease is a Fulton County Jail. And so what I am asking for a bond so that he would be released to a mental health care facility. A mental health care facility whereby he would have an ankle monitor attached to him and he could actually receive the treatment that he wants so that we can say, or that I can say with confidence at some point, if he is receiving the treatment that he needs, that he does not pose a risk to society or a risk of flight or a risk of committing a felony. You know, last night someone hanged or hung, I'm not quite sure which is proper, himself at the Fulton County Jail and killed himself. So that is where Mr. Espinoza is housed right now, and his condition, since he has been in that place, has gotten worse than it was. So he poses a significant risk of committing a felony while he is there, because he is there. He poses a significant risk of flight to the extent that the ultimate flight is death. He poses a significant risk to everyone with whom he comes in contact as long as he is in the Fulton County Jail. His list of medications is too long for me to even read out loud, and certainly too complicated for me to pronounce. So, the Fulton County Jail is either unwilling or unable to house him. The Fulton County Jail is either unwilling or unable to provide him the proper medical care. So I'm asking for a bond, a water bond, with the condition that he have a monitor on his ankle and that he be in an inpatient 24-hour mental health facility. That is what he needs, and I'm asking the court to allow that. Thank you.
Thank you. Mr. Greiner?
Thank you, Your Honor. My colleague is correct that this defendant falls under each of these IL factors. He is a flight risk. He is a threat, danger to the community. He is a risk of committing further crimes if released. He's also a risk of intimidating witnesses. But an ankle monitor is not going to protect society from Mr. Espinoza. What occurred in this case, very briefly, was back on February 7th. Mr. Espinoza is seen walking across a parking lot at 1425 Market Boulevard in Roswell, Georgia, here in Fulton County. There's what's called the Ace Pickleball Club, and it's a recreational facility. Mr. Espinoza walked into that facility, and the first thing he did was he drew a gun, and then he put it back into his vest. There was a lady who may have worked there, but she had a conversation, a very brief conversation, less than 2 minutes, with Mr. Espinoza, and for want of a better word, convinced him to leave. But during that conversation, he mentioned his desire of wanting to kill members of a certain group. And of course, that alarmed, it would alarm any reasonable person, and the police were contacted. The video is very, very clear, some of the best video I've ever seen. Mr. Espinoza goes around the building and goes to a Publix. He comes out a few minutes later, and he's holding a green shopping basket with some items in it. And he comes walking right back across the parking lot where the Ace Pickleball Club is. And that's when Roswell Officer Labonte arrives. The officer stops his vehicle, gets out. Mr. Espinoza actually kind of curves his pathway and turns back over to meet with the officer. And for a few seconds, they stand just a few feet apart, conversing. Mr. Espinoza sets the green basket down, stands up, draws that same handgun, wraps around, and shoots. His first 2 rounds go into the upper part of the officer, not covered by a protective vest. The officer falls. And then at that point, this defendant walks carefully around, leaning over, and fires more than a dozen shots into the fallen officer. He leaves the gun there, and then he runs away with his arms held high. The gun he used was an illegal gun. It's a ghost gun. No serial number, not traceable. If he can find and purchase that kind of thing on the internet, he doesn't need to be released. He's got the mental capacity to handle the Fulton County Jail. He was arrested within minutes by other members of the Roswell Police Department. He gave a statement to the police during which he acknowledged shooting Officer Labonte. This is not a case where self-defense is going to be a reasonable defense or a question of who the identity is. We've got very crystal clear video. He had blood on his clothing, although he was not injured. And one of the reasons that he gave for his actions was he did not want to go back to jail, and he did not want to receive more mental health treatment. So, Your Honor, for all these reasons, we move that the defense motion, if there is one, be denied, and that in no way, shape, or form that this man get a bond so that he can get out, go to any kind of facility. There's no facility that can protect him like a jail cell. Medication is not the solution here. He gave a lucid interview. An ankle monitor is not the solution. No bond, that's the solution. I would also point out, Your Honor, that in consideration of his history, he was arrested for, back in 2021, September 23rd. he was shooting a rifle out his apartment window at night. And of course, and that was in a public area. And of course, that alarmed other members of the apartment complex. Police responded. He was very disrespectful, and he was arrested. He bonded out on that case back on September 24th of 2021. He then got arrested several months later before the reckless conduct case had been resolved. He got arrested for criminal trespass on June 14th of 2022 while he was out on bond. Bond should have been revoked, but it wasn't. He was granted a new bond, and he got out. He ended up entering a plea as a first offender to the illegal discharging of a weapon case. He did complete 1 year of probation. He did receive mental health treatment during that year. Apparently it didn't work, because just within a few months after that, he got arrested yet again for simple battery, criminal trespass, and public intoxication. He was then granted a bond again on September 24th of 2024, and now we have this incident on February 7th of 2025. So we respectfully ask the court to not bond.
May I very briefly?
Okay.
Other than the conclusion, I don't disagree with anything Mr. Griner says, and I will never be as articulate as he is, and I will bumble my way through saying that he pretty much said many of the things that I would say. Mr. Espinoza suffers from irresistible delusions.
Mr. Espinoza, you need to try to stay quiet. Okay, during the hearing. All right, your lawyer's talking on your behalf.
My lawyer? Thank you.
Goodbye. Thank you.
He suffers from irresistible delusions. Those delusions that sometimes make him believe that people are trying to kidnap and or kill him. And sometimes he acts on that delusion of believing that people are trying to kidnap and kill him, even if they happen to be wearing law enforcement uniforms. So people who may be here to protect and serve, he sees those people if they are coming toward him as kidnap and kill, and he suffers and acts under that delusion. What has been done thus far has not worked. There has been the attempt to handle it as merely a criminal justice matter, when this is a mental health matter. He's a man with a mother and father, a brother and sister, lived right here in Fulton at Centennial High School. He's never been convicted of a felony offense in his life. However, he needs help, and I am asking this court to allow him to get that help at a mental institution, a place that is designed for people who are a risk to themselves or others. Those are part of the words of the K-13. If you are at risk to yourself or others, the proper procedure is to put you in a place that is designed to care and treat you. That place is not the Fulton County Jail, and I ask this court to handle this in a manner that is different than what has been done before, but in a manner that would be more effective.
Thank you. Mr. Ryers?
Yes, Your Honor.
Okay, thank you. All right. Obviously, given the fact that the parties both agree that Mr. Espinoza is a significant danger to the community, he's a risk of flight, he's a risk of committing additional felonies, bond is not appropriate in this case. Mr. Ryers, if you believe that an ex parte motion or a motion for a mental health evaluation needs to be done in this case, then you as an officer of the court need to be filing those kinds of motions. That's not the way we handle it. Is at a bond hearing where the court orders someone to be committed to a mental health institution. Not the way it works. Given Mr. Espinoza's criminal history involving firearms, his history of bond violations, the fact that at the time that he allegedly committed this offense, he was on bond, and that bond had a condition that he was not to possess any firearms. I do not believe that he would abide by any bond conditions that this court could impose. And therefore, I'm going to deny bond. I oversee the Fulton County Behavioral Health Treatment Court, our mental health court. I'm very, very familiar with what the Fulton County Jail is able to do to treat individuals who are suffering a mental health crisis. And so I have faith that with the appropriate motions, the Fulton County Jail and state agencies are able to give Mr. Espinoza the treatment and medication that he requires, while still also keeping this community safe from someone that you, in fact, agree is a danger to the community. And so, bond is denied.
I thank you, Your Honor, for listening, considering it.